All right, in today's video, we're going to discuss how we acquire ownership in real property and also how we lose ownership in real property. Now, before we get started, there are certain key real estate terms that you're going to need to know for the real estate licensing exam. And they are involuntary alienation, bequeath, testate, intestate, executor, executrix, testator, testatrix, devise, devisee, and probate. And as we go through this video, we're going to address each one of those key real estate terms. All right, so let's deal first with acquiring ownership. There are three ways that one acquires ownership in real property. And they're on the board here. The first one is voluntary alienation, and the key or the root word here is voluntary. This is where the seller simply voluntarily passes title to a purchaser because the purchaser and the owner agreed to terms. This is the most common. I offer you a certain amount of money for your house and you accept, and we go to closing and title transfers. Now, the second way one acquires ownership in real property is by a will. That means somebody died and left them some property. So let's take a look at how that process works. So when somebody dies with a will, they are known to have died what's called testate. Testate, that's one of those key words. Now let's identify the parties here. If it's dad who died, dad is legally known, because remember, dad died with a will, he is legally known as the testator with an O-R. Now if it's mom that dies, she is known as the testatrix, R-I-X, testatrix. Now, mom or dad, depending on who died, let's say dad in this scenario, in his will, he nominated an executor or an executrix, depending on if they're male or female. So let's executor and executrix, R-I-X on the end. And it just means masculine and feminine. All right, so dad owns property. He has this house, and according to the will, he wants it to go to his kids. And he's got two sons. All right? And one of the sons can be the executor. It really doesn't matter. So what happens is, as the executor carries out the wishes of the dad who died via the will, then title's going to transfer from dad or dad's estate to the kids. The property itself is legally called the devise. That's the legal term for the property that's being willed. Therefore, the people that are receiving, in this case the kids, that are receiving the willed property, they are called the devisee, with two E's on the end. The devise and the devisee. So that's the second way that someone acquires ownership in real property. Now, the third way that somebody acquires ownership in real property is as the result of somebody dying, but it's somebody who dies without a will, and that's by descent. So when somebody dies without a will, they have died intestate. And the property is going to go by descent. No will here, no intestate, no will. All right, so let's go through the process of how that works. So dad dies, but dad did have a piece of property and he does have two sons, okay? They call it descent because dad's interest is going to descend down his familial line. So if his kids were gone, it would go to his grandkids and his great-grandkids and so on and so forth. All right, so what's going to happen is they're going to open up probate. So if somebody dies without a will, typically what has to happen is someone has to open up probate, and then typically the probate court will decide who the executor or the executrix is, so they can carry on the duties of closing out dad's estate. So what's going to happen here is the ownership in the house is going to go to the kids. And again, whoever was appointed by the court to carry out the closing out of the estate will make a determination of how that is designed. Typically, it's established by statute, so most of the time, both sons would get 50% ownership. All right, the last thing I want to talk about here, because I know I'm going to get a question. Now, what happens if dad, this is his third marriage, okay, and he has a wife. So he died without a will, and he's got 2 kids by a previous marriage and a third wife. What is the wife entitled to? Well, it depends. So if dad and the wife, they're holding title to the house in what's called joint tenancy with rights of survivorship, then actually what happens is the house goes to the wife, straight up. It's joint tenancy with rights of survivorship, so the joint tenants have the rights of survivorship. But let's say that the house, let's say the dad and the wife, they had no joint tenancy with rights of survivorship. Then what happens? Well, in most states, there is a statutory protection built in for the spouse. And depending on the state, it's anywhere from 1/3 to 1/2. So the wife in this case is going to be entitled to 1/3 or 1/2 at a minimum of dad's estate. And then the kids would get the rest. And that's the recipe for lawsuits. And I've seen several doozies because of that very thing. So I guess the moral to this story is make sure that you have a will. Always have a will. Now, the way someone would lose ownership in real property is called involuntary alienation. Now, remember from earlier in the video, when a seller sells the property, that is voluntary alienation. But when they lose ownership against their will or in a hostile manner, that's called involuntary alienation. And it's done by what's called adverse possession. Adverse possession. And that's a key real estate term that you're going to have to know for the test. So here's how the process works. To be successful, for a claimant to be successful, they have to make sure that they have qualified. So let me set you up with this scenario. We have 2 pieces of property. All right, one has a house and it's owned by Tom. And this is a vacant lot right next door. And Tom has been trying to get a hold of that owner because he wants to buy the lot, but he's been unsuccessful. No one knows where the owner is. So someone gives him the idea, maybe a real estate instructor, that, hey, maybe you should try to get that by adverse possession. For Tom to acquire ownership of that property via adverse possession, there are some essential legal elements that must be fulfilled. Now, for Tom to succeed in obtaining title to this vacant lot using adverse possession, these 5 essential elements must be met. It has to be for a statutory period of time. It has to be in a hostile, actual way, distinct, visible, and continuous. So let's take a look here. Let's say, here's what Tom has to do. He has to put up a fence. He has to appear publicly that he's taking care of that lot. So quite frankly, when somebody's walking by, the general public will have no idea that Tom does not own that vacant lot. So he has to keep that up for the statutory period of time. And he has to be able to prove that in front of a judge at the end of that statutory period of time that he was the caretaker for that property. It must be in a hostile and actual way, meaning he's participating in the care of that property. Hostile to the owner, meaning that he didn't get the owner's permission. That's basically what hostile means. He did it without the owner's permission. It's distinct, it's visible, and it's continuous. This is important because the statutory period of time plays into it. He can't lay claim to this and take care of it for 1 year, then take a week off, then another year, and then a week off. It has to be for that entire statutory period of time. All right, now that Tom has completed all of these essential elements, he's going to go into court and file what's called quiet title action. And that's another key word that you have to know. Quiet title action. And when he files quiet title action, what he's technically doing, he's going in front of the judge and say, Judge, I am claiming color of title. Color of title. Color of title simply means that I'm acting like the owner and I did everything the owner would normally do, but I'm not the owner, and I've done it for the statutory period of time, and I've done it in actual distinct and visible way. I'm entitled to the property. Now, if the judge agrees, then the judge will pass title and give ownership to Tom, and Tom will own this vacant lot. That's called adverse possession. It's a key real estate term that you do need to know for the licensing exam.